Citizens Property Insurance Corporation versus San Perdido Association Incorporated. Council members.
Thank you. May it please the Court, my name is Anthony Russo, and I'm appearing on behalf of Citizens Property Insurance Corporation, and I would like to serve 5 minutes of my time for rebuttal, if I could, please. Citizens commenced these appellate proceedings with a petition for writ of certiorari, or in the alternative prohibition, looking for an order that would stop the trial court from adjudicating San Perdido Condominium Association's 624.155 action against citizens.
Why doesn't Department of Education versus Roe direct us to deny that and send this back down and allow the case to proceed to trial?
Judge, I'm not familiar with exactly what case that stands for. Is that a jurisdictional question, sir?
No, it isn't. In fact, it specifically is not. It's a Supreme Court case from, I believe, 1996, which specifically says that governmental immunity, that a governmental entity is not entitled to interlocutory review and a motion to dismiss unless it's in a qualified immunity case on a federal civil rights case.
Which, in that immunity, is not at issue here.
Correct.
What we have is a specific statute, a legislative enactment, Citizens 627.351, that created citizens and made it a sovereignly immune entity. And there are several cases that we cited, both recognized under petition for cert and petition for prohibition.
Well, one of the cases, go on, I'm sorry.
Sovereign immunity goes to the subject matter jurisdiction of the trial court to proceed.
And I think one of the cases you cited was the Circuit Court of the 12th Judicial Circuit.
Yes.
And that, in fact, in the Department of Education case that I'm talking about, that case specifically addresses that 12th Circuit's case and says that's how we used to handle things. Says we used to consider these matters a matter of jurisdiction.
It's possible.
In fact, here, let me quote it for you. It says, in fact, at one time, suits such as this would have been dismissed for lack of subject matter jurisdiction without regard to merits of the underlying claim, and it cites that 12th Circuit case. I read that as saying that since at one time that's how they were handled, they're not handled like that anymore.
7-6, I believe that might be, that statute, that case may be addressing the Tort Claim Act and the effect that the waiver of sovereign immunity under the Tort Claims Act affects the jurisdiction of the court. The Tort Claim Act does not obtain or apply in this case. What we have here is a separate, unique entity, Citizens, with its own statute, 627.351, and we're not dealing with the Tort Claims Act or Chapter 768.28 and the immunities and the procedures that are involved under that statute. Plus, we have the Garfinkel case, which I wanted to get to, because after we filed the petition for writ of certiorari or prohibition, the Fifth District Court of Appeal, of course, issued its decision in Garfinkel versus Citizens versus Garfinkel, which issued a writ of prohibition, acknowledging that subject matter jurisdiction was involved when a trial court adjudicates. Or
do you agree that the cases are just kind of all over the place as to whether appellate courts should take up this issue on an interlocutory basis or should just send it on to trial? I mean, do you agree that there's just cases every which way?
I disagree with that respectfully, Your Honor. I believe that the cases are very clear that certiorari or prohibition will issue from a district court to stop a trial court from acting outside of its jurisdiction.
But how is jurisdiction implicated here? Are you suggesting that the trial court lacked jurisdiction?
Lacked subject matter jurisdiction. Yes, and we briefed that, I think, in our initial petition, how that sovereign immunity invokes that a sovereignly immune entity cannot be prosecuted in a trial court. And so sovereign immunity involves the subject matter jurisdiction of the court, which is why prohibition is one appropriate remedy.
Well, I think what Judge Clark is asking you, I think with a friendly question, that there are cases suggesting, as the Roe case did, that the district courts do not have, they certainly don't have interlocutory appellate jurisdiction, and that they should not exercise their extraordinary writ jurisdiction. But I think maybe a better case for you is an Indian case out of the second DCA where the court did review on cert jurisdiction their claim for immunity. And in this case, unlike a tort waiver of sovereign immunity case, you have a statute that you read as providing absolute immunity almost. Is that a better statement of where you are?
Yes, sir. And I appreciate pointing out a friendly question.
Well, but did you say absolute immunity?
Or maybe absolute wasn't the right word.
Okay, because I was going to follow up on that it's.
Well, let me skip that. That may be a different.
All right, because it really isn't absolute by any means. It sets
right.
forth two exceptions.
You are correct about that. But let me ask a question, and maybe the debate about jurisdiction is one that we can explore more. Am I reading the Garfinkel case correctly, that the motion to dismiss there was denied, and some time passed before an original writ petition went to the appellate court on the issue of the dismissal? So you really didn't have cert available to you in that case, did you?
That's correct, Your Honor. There were several orders. One, a motion to dismiss was denied. Several months passed. There was some discovery. An order was entered. I think some additional time passed. And then the petition for cert or in the alternative prohibition was filed. And we added the prohibition because there is not the 30-day time limit that goes with the certiorari petition requirements.
If we were to reach the merits, am I correct in assuming that you would ask us just to take the fifth DCA and the case style off the Garfinkel case and put a first DCA and our case style in this case on it, and that would be the decision?
Yes, sir, and I think you can do that. And I'd point out one important fact for the court is that the complaint of the association, which is in our appendix, tab 1, page 10 of that complaint, identifies the single cause of action as one for under 624.155. So it is absolutely brought under that statute. It's not style breach of contract. It's not style tort. And that is exactly the same facts as was found in the Garfinkel decision. So I think we do have a case that is on all fours, and I'd warn the court that those being so close that any divergence of opinion might be a cause for further review in the Supreme Court.
But didn't the fifth, just a couple of months before the Citizens case, just a couple of months before that in Florida A&M, I believe, versus Thompson, didn't they refuse to take up a sovereign immunity issue on interlocutory review?
I'm not aware if that was
That's Florida A&M versus Thompson. And I believe they cited Roe in refusing to take the issue up on a search or a prohibition.
And my initial impression, Your Honor, would be that was probably a tort claim act under Chapter 768. But that's the first thing I've looked for in that opinion. But I cannot answer the question.
And I'm not sure why that would matter. The Supreme Court statement in Roe specifically says that interlocutory review is just not appropriate to review question of immunity unless it's qualified immunity. And I'm having trouble getting past that.
Well, the sovereign immunity cases that we have cited both in the initial petition and in the reply identify sovereign immunity, which is something different than qualified immunity.
Certainly it is.
And I think perhaps that might be the distinction.
Well, the only reason they did that was because of the federal court decision of Tucker versus Raisha that said that these qualified immunity under 1983 would be reviewable. And so the Supreme Court said, okay, those will be reviewable, but not on others. And when the Supreme Court asked the Appellate Rules Committee to consider whether to adopt a rule to allow interlocutory review, be it by certiorari or interlocutory appeal, of all of these sovereign immunity types of cases, the Supreme Court sent it to the Rules Committee to consider, and then decided this case and said, now, when the Appellate Rules Committee sent it to them with the entire plethora of sovereign immunity, said, no, we're just going to do the Tucker versus Raisha because we're required to by the federal courts.
Are you speaking to Rule 9.1.30, qualified immunity?
Yeah, because at one point they tried to have sovereign immunity brought under that as workers' comp immunity was added. And the Supreme Court said no, and that was about the time they decided this case of Roe, and said in Roe that we're not going to permit interlocutory review of sovereign immunity cases. Somebody's got to decide whether there's the trial court, or somebody has to decide whether there's a sovereign immunity in the first place. So they have to have jurisdiction to decide their jurisdiction. So it becomes a kind of a mess. That's why they did that.
Is there a distinction in your mind between immunity from liability, such as qualified immunity, Indian immunity? Excuse me, I said that wrong. Immunity from being sued, such as qualified immunity and absolute immunity, Indian sovereignty immunity, and immunity from liability, such as 768-20.
There is a distinction, and I believe the enabling statute for citizens says immune from liability and from suit, just as it's established for the other entities, FIGA and the JUA entities for medical malpractice.
So you would argue to us that the policy rationale for us taking cert review would be consistent with the policy rationale for qualified immunity and Indian sovereignty immunity, more so than immunity from liability, such as in the tort actions?
I would have to argue for the greater immunity, Your Honor, and I apologize for not being able to address this question any more specifically, and I request an opportunity to brief it if it's that much of an issue for the court, because it was not with the Garfinkel case, with Garfinkel court, which adopted the prohibition arguments that were made. It became the law, and so that was not the focus of these proceedings. If it is a problem, then I would ask the court to ask us to brief this question specifically, because if it's that important, let's...
All right. We ask you to brief it, and we ask for a reply to that brief.
Very good.
But we have a question, too, and I'll extend your time if we need to, but the exclusion for negligent acts or willful acts under the statute, where the insurance treatises define bad faith as a willful act, how do you get around that?
There are two. There is an exception for willful torts. Section 624.155 is not a tort. That's what Garfinkel court came to the conclusion of. Subsection 8 of Section 624.155 says this statute shall not be construed as creating a common law cause of action. So, number two, aside from the precedent, we have the statute.
But that doesn't mean it's not a statutory cause of action, right?
It creates a statutory remedy. That's right. It would be unworkable. I think Section 64.155 enumerates a number of different actions that, if taken by an insurer, a private insurer, allow a remedy. Some of those are mere inadvertence, those acts. Some of them are willful, wanton, and malicious acts. Some of them are intentional acts. Now, if there's only an exception to immunity for the willful acts, I think it would be very unworkable and maybe impossible to say that citizens is immune to some of the causes of action under 624.155, but not others.
Let me ask this question, because this has been bugging me. I mean, I've read the Garfield case and find it certainly to be persuasive to look at. And I may completely buy their position that bad faith action is not a willful tort, but what would be a willful tort that Citizens Insurance Company would be committing? They're not battering people.
Well, that would be a willful tort. Willful tort, Your Honor, as I've looked at it, includes actions that are intentional in nature, but the subjective intent, there's no proof of the subjective intent, but the law supplies the the necessary intention because there's an appreciation. There should have been a reasonable appreciation for the danger. For instance, at a crowded New Year celebration, I fire a gun into the air, knowing the bullet's going to come down. I have no subjective intent to hurt anyone, but a reasonable person would expect that bullet to hit somebody and hurt them.
But your
That's a
citizens
willful
wouldn't do that. Give us one that fits the category in the statute.
I hate to argue against my own client, and I don't think I can. A willful tort is one. A tort is.
Is there one that can come in?
It could be, let's say, an adjuster is purposefully
Acting in bad
rude.
faith? Purposefully acting in bad faith?
Purposefully doing something to injure a plaintiff.
Well, bad faith injures a plaintiff.
It is something. It can be something more than intentional as well. I will tell you that in the criminal law context, intention and willful are equated.
And of course, the statute speaks in terms of any willful tort, not just a list of specified torts that you might be able to think of.
Right.
And
Any willful tort.
The biggest irony to me is in the 768-28, where the state is liable for acts and omissions of its employees.
Yes.
It specifically isn't liable for willful, malicious, and those sorts of actions. So here we have what seems to be the
Yes.
converse. And
That is true.
it's very curious.
And we also have a provision that says that citizens has to act in good faith.
Yes, and that is not an exception to the bad faith, to the immunity that's found in a different subsection of the statute. It is a command to those people who are charged with running citizens to execute their duties in such a way, but it does not create an exception to the immunity.
All right, you've run over, but I'm going to give you 1 minute for rebuttal, and counsel, I'm going to add 1 minute and 47 seconds to your time, if you need it. Yeah, counsel, what we're going to do is we're going to send you an order defining the issue we want you to further brief to make it clear for you.
And then we will be
And
required
we'll
to
have the
respond to
opportunity
those.
to respond. And we'll give you a time period.
May it please the court. My name is Richard Beckish. I work for the Libris Law Firm, and I represent San Perdido Association, the appellee in this case. Citizens is a governmental entity. We aren't arguing that. It says so in their enabling statute. But it's a government entity with very limited immunity. And there are actually 4 exceptions to that immunity, but there are 2 that are at issue in particular here today. One is the legislature saw fit to say that citizens can be held liable for breaches of its insurance contracts, and the other for willful torts. So that leaves this court with 2 very important questions that really cut to the nubbin of what we're here about today. The first is a violation of 624-155, Florida's bad faith statute, a willful tort? And the other question is, if so, is there any reason to believe that the legislature intended to make an exception to the exception and exempt citizens from bad faith liability?
Before you get to those 2, you would agree that the second exception to their immunity involving breach of contracts is not at play in this case, is it?
Well, Your Honor, we actually argued it in the alternative in the court below, and at one point, citizens during their brief made an argument that bad faith was an action ex contractu, and our response to that was simply, okay, fine. If you want to say that it's a contract-based action, that's still exception number 2. But we actually believe it's a willful tort.
Well, and the reason I ask is because the way you phrased it a moment ago, that one of their exceptions is responsible for breaches of the insurance contracts. I understand the record in this case. You've already recovered on a breach of insurance contract.
Absolutely.
Cause of action. So how could this action that's pending below be a breach of contract action?
Okay, because the nature of bad faith itself. It's a breach of a duty, okay? But what citizens argued was that, well, it can't be breach of contract, and they made the very argument that Your Honor put forward. We're not trying to recover on the contract again, of course. It says, where does the duty that is breached come from? And that leads to, again, our position is that this falls more properly under the willful tort exception. Okay.
And I'm just trying to make sure we're all talking the same language here,
Yes.
because I just don't understand how the bad faith action that you're pursuing could conceivably be a breach of contract action, because I understand contracts have implied duties of good faith in it, but there's a defined remedy you get.
Right.
Here, the statute provides something more, so it's got to be something other than the
And, Your Honor, we agree with you.
Okay.
We were just simply responding to an argument by the other side.
All we're dealing with here, then, is the willful tort.
Willful tort.
So why, then, should we not go along with the Garfinkel case, who answered that question?
Because with all due respect to the Fifth DCA, Garfinkel case got it wrong. Because what happened was, when you really boil this thing down to the nugget, the question this court has to answer is, first of all, what is a tort? Now, a tort is one of the two pillars of our civil law. I mean, our civil causes of action are basically torts or breaches of contract.
Well, if we decide that that isn't even appropriate for us to review it at this time, then we don't decide any of that.
Then what will happen, if you decide on the basis of the
do
jurisdictional issue that was...
Do you agree, prohibition, right, or certiorari, that there is a right to review?
Your Honor, I think it probably does, and even...
Under prohibition?
I'm sorry?
Prohibition?
Prohibition?
Who would decide whether it was a willful tort, whether the exceptions applied, if the trial court didn't have jurisdiction to pursue it?
Somebody's got to have jurisdiction.
Right. Somebody has to, you're quite correct. Somebody has to have jurisdiction to decide this question. My concern is that if this court doesn't have jurisdiction to decide this question at this level, then what's going to happen is it's going to go back down to the trial court and then be right back up here on summary judgment, which almost seems like a waste of this court's time, even though maybe technically, in a legal sense, quite correct. But the issue of whether this is a willful tort, this court has got to decide a very basic question in our law. What is a tort? Now, I noticed that in their brief, Citizens cites Professor Prosser from a 1971 version of his book, Prosser on Torts, and in that he basically threw up his hands and said we didn't have a good definition of it. Well, the fact of the matter is, some 14 years later, in the 5th edition, 1984 edition of his book, at pages 164, 165, he gives a very concise definition of what a tort is, which I think that most legal scholars and most lawyers in this country would agree with. He says, quote, "A tort is a breach of a duty imposed by law which results in a reasonably foreseeable damages." Now, where the Garfinkel case stumbles is they seem to believe that the duty can only be imposed by common law. And there is not a single case in this state, there is no authority for that proposition whatsoever. Their entire case hinges on that point.
Let me ask you this from a policy perspective or a practical perspective.
Yeah.
They cite the Spangler case saying that we should construe exceptions to sovereign immunity very narrow. And from a public policy perspective, why would that not be the right thing to do in this case? Construe willful tort very narrowly. More narrowly than you're suggesting to include statutory torts, to construe it to mean willful common law torts, because we know, we don't know in this record, but Citizens is not the most flush with cash agency. The legislature's having to infuse capital just to pay the claim that's already got out there. Why should we now open it up to paying even more than it is contractually obligated to pay?
Well, Your Honor, for a number of reasons. First of all, because there is no authority out there saying that torts are limited to common law torts. That would be an extreme narrowing of the law. As a matter of fact, statutory torts have existed in the state of Florida since 1935, and we cited you a number of cases which, have said so. So they're including.
And there's been no court that has said there's some grand distinction between statutory torts and common law torts.
No.
I mean, a tort is a tort.
Tort is tort.
Is there any case that says a statutory tort would not fall within the purview of a willful tort?
No, Your Honor. Willful tort just simply adds the character of willfulness here, which is in 624-155. It says willful violations. So that's what makes it a willful tort. It fits all the Professor Prosser's definition of what a tort is. And if it walks like a duck and quacks like a duck, it's a duck. I mean, it talks about a breach of duty. Now, let me go back to your question, Your Honor. What did the legislature create them for? What are the citizens of this state paying taxes to support them for? Because what they are asking you for here, flat-footed, is to be able to act in bad faith towards their policyholders with impunity. That is what they are asking for, no more, no less. And if you
aren't they saying, unlike a corporate entity who can do that with impunity, arguably, here they are accountable through the elected officials who serve as their head?
Well,
devil's advocate.
Actually, they're not, Your Honor. What happens is a board is appointed. So what they're saying is we'll self-police, which that obviously hasn't happened. It hadn't happened in this case. And again, I go back to the question, what is the justification for their existence? To protect their coffers? To collect insurance premiums? To give a good living to their executives? I mean, a regular insurance company at least has the bad excuse for bad behavior to say we're maximizing the wealth of the shareholders. They don't even have that. Citizens was created by the legislature in order to have an ability to rebuild after a disaster. Now, if they are able to act in bad faith with impunity, how does that further that purpose? Moreover, the legislature also incorporated into their enabling statute a duty of good faith. Quote, the corporation shall manage its claims, employees, independent adjusters, and others who handle claims to ensure they carry out the corporation's duty to its policyholders to handle claims carefully, timely, diligently, and in good faith. Now, granted, that language in their enabling statute does not raise a cause of action. They claim that. But if you interpret tort so narrowly as to only say it means common law torts, and allow them to act in bad faith, then the duty of good faith, which is in their enabling statute, is just flowery language. It basically becomes meaningless.
So where they would ask us if we reach the merits to simply adopt the analysis of Garfinkel, you would ask us to come to a different conclusion and necessarily certify conflict.
Absolutely. This is a question of prime importance to the people of this state, Your Honor. And there's one other reason why you shouldn't buy into this argument of, oh, our coffers are low. If you simply hold them to the standard of good faith, like every other insurance company, if you say you cannot act in bad faith towards your policyholders, that doesn't mean their coffers are going to be drained.
It actually kind of feels like you're getting far afield here, because the only issue we really have to decide on this point is whether or not bad faith is a willful tort. I mean, it's not our job to figure out the public policy and their coffers, and we really just have to figure out whether or not a bad faith action falls within a willful tort. Let me ask you this about your definition of torts and bad faith. On a bad faith action, are punitive damages available?
Yes. Under 624-155, punitive damages are available if it is willful, and you also have to show that it was not a singular event, that it was multiple breaches of the
Are punitive damages available in any other cause of action except for torts?
No. Breaches of contract, there are very specific prohibitions in Florida law that say you've got a breach of contract action. No. The only time you get punitive damages are in tort.
Is there any other cause of action you're aware of against the state of Florida or one of its entities that would allow punitive damages to be recovered against it?
Not that I'm aware of, Your Honor, because
So wouldn't you expect if the legislature was going to authorize punitive damages to be awarded against one of its entities that would have said so a little more clearly than this willful tort, good faith, back up here to bad faith claims?
Well, Your Honor, I mean, I don't think that it has to, that the state or the legislature in crafting a statute, even their enabling statute, has to be so painfully explicit that I don't think they have to meet that level of specificity. If they're saying a willful tort, Your Honor, right then and there, you know that there's a potential for punitive damages. If you think about willful torts, fraud, bad faith, they all carry, intentional infliction of emotional distress. You name me one willful tort that doesn't carry the potential for punitive damages. The legislature surely knew that when they wrote this.
It is kind of curious, as I've said, in the 768-28, where they the state immunizes itself from willful acts against employees, but here, whatever willful tort means, it provides there is liability.
And I think it's an indication of the legislative intent that they specifically did, carved out this exception, said they're liable for this. Because if you remember in their brief, they talked about the FMMJUA and the FIGA statutes and claimed they're identical and that there are cases that say that they're not liable for torts. Well, the problem is they're not identical because both of those statutes, although they're identical to each other, they do not have this specific exception that applies to citizens. So we got to assume that the legislature knew what it was doing when they carved out these exceptions and said, we're going to make these guys total all right.
And that would be something you would point us to, I would assume, in the Garfinkel case. It was a little thin on analysis.
Yes, Your Honor. As I said, what they didn't get to, the question they stepped around by simply applying a label of this is a statutory cause of action. Why does willful tort have to be only common law based? Where does that come from? Why are we creating a whole new area of law called statutory causes of action to accommodate citizens? The 5th DCA dropped the ball on that one. I see that my time is up, and I thank you on behalf of San Perdido Association and the policy holders in this state.
1 minute, Your Honor. There is an important question here regarding the jurisdiction. We will address it. I think we will show that it's important that this court can recognize these causes of action on an original writ and through its original jurisdiction. I'm predicting that we'll be able to show that to the court's satisfaction. I also predict that we'll be able to show that 624.155 is not a willful tort as is excluded, and I've got to object on behalf of my client that the citizens of this state are protected from abuses from Citizens Property Insurance Company, and it can be made whole through the exclusions that already exist for breach of contract, for attorney fees, and for willful torts. And they have been made whole, and they are in the same position that every Floridian was in before 1982 in the enactment of Section 64.155. There is no systemic risk to citizens being heavy-handed with its people, with its insureds, because it does not have a profit motive. It doesn't pay out bonuses. It doesn't have hungry shareholders to feed. And finally,
well, but that still kind of goes beyond whether or not bad faith is a willful tort, doesn't it?
And that is another, and my final point, Your Honor, is that is not a simple question, and that is something that probably should be addressed by the parties in this further briefing as well. What is a willful tort? And battery.
Well, that really was addressed in your pleadings.
We did mention it, yes. But I think it is something that It's not as simple as what my opponent makes it out to be.